Well, hi, everybody. Hope you all enjoyed lunch and are awake for this afternoon's panel with us. As he mentioned, my name's Patrick Reilly. I am a partner with the law firm of Faegre Drinker Biddle Reath, and I'm located in Indianapolis in the United States. And as he mentioned, we're here today to discuss coordinating the defense of complex litigation in Europe and globally. So why don't we meet our panelists here. Guys, if you can just introduce yourselves kind of briefly, and then we'll kind of get a little bit into your background and kind of how it relates to our topic today. So Edu, why don't we start with you?
Okay, afternoon everyone. Eduardo, Brazilian attorney. I've been working at Uber for 5 years now and overseeing the international insurance litigation.
My name's Ainslie Cranwell. I work for the Volvo Group.
Good afternoon, my name is Felix Bannaby and I work for Mercer as legal counsel.
Great, well, thank you guys for your time and for joining us. So I think it'd be helpful for people in the audience if we delve a little bit deeper into our backgrounds and particularly kind of how we're familiar with the subject that we're talking about today. Again, coordinating the defense of complex litigation in Europe and globally. And then perhaps if you can kind of just touch on what you do, in your daily roles, and again, kind of how it relates to this particular topic. I'll give an example. Maybe the audience is wondering why a guy from Indianapolis is moderating a panel on the coordination of global and European litigation, which is a fair question. My practice is product liability and mass torts. And we heard some really good discussion earlier from some of my colleagues and, well, maybe my compatriots from the United States on the state of litigation there. You heard about multi-district litigation and class action litigation. And that's really my practice, which is now kind of extended to coordinating the defense of litigation for clients in Europe. And so, Felix, why don't we start with you? If you can kind of just go into a little bit about, again, your background, kind of your daily role, and then, again, kind of how it touches on this particular topic.
Sure, thanks, Patrick. So my name is Felix Bannaby, as I said. By profession, I'm a qualified barrister, would have trained in the UK, got my law degree here. I'm originally from the Bahamas, and so after qualifying, I went back to the Bahamas where I worked in private practice for 6 years. My general areas were litigation, particularly in civil and commercial litigation. In the Bahamas, we don't have a distinction between solicitors and barristers, and so I pretty much did both roles. A lot of my clients at the time were financial institutions, and a lot of my claims surrounded breach of contracts or contractual disputes. During that 6 years, it was my introduction into cross-border litigation. The firm that I worked for had a lot of contentious matters in the US as well as in Europe, and so a lot of my experience there came from working in private practice. For the last 4 years, I matriculated back to London, where I've been working in-house with the company that I'm at now, Mercer, which is a professional services firm. At Mercer, I am responsible for a lot of the litigation that happens there. I manage and supervise the errors and omissions process, which pretty much is an internal process where we take in complaints and those complaints materialize to litigation. Sometimes there's settlements involved, and so I manage that with a team of paralegals and junior lawyers. I've been here for a while in terms of my experience with global class action suits. We are a global corporation, and so we have different branches all over the world. Our head office is in the US, and so I liaise heavily with the attorneys in the US as well. So that's me in a nutshell.
Yeah, that's perfect. Thank you, Felix. All right, Ainslie, what about you?
What about me? I am Australian. I trained in Australia. I did a few years there, and then I moved over here. The majority of my career has therefore been spent in England, and I'm now working for a Swedish company. So I have a background in general commercial litigation. I was with Herbert Smith for 12 years, and I have moved in-house to work with the Volvo Group. When I was with Herbert Smith, I was working on the big class actions that they work on, defendant side, which is why I have transitioned to working in-house defendant side as well. At Volvo, I'm working on the trucks litigation, and working with our external counsel managing the claims in the various jurisdictions around Europe. that we're facing.
That's great. Thank you, Ainslie. Okay, Edu, last but not least, what about yourself?
I started my career defending insurance companies, insurance litigation in Brazil, overseeing mostly of general liability claims for international accounts. After that, moved to financial lines, working with GNO, mostly during the huge investigations that were in Brazil. Moved to Uber to oversee insurance litigation in Brazil as well, starting building the team there. After that, expanding to Spanish-speaking LATAM. So all the countries you operate in LATAM, I was handling the litigation matters. 2 years ago, expanded again, overseeing EMEA and APAC. So all the mega regions that Uber operates nowadays outside the US, I'm overseeing all sorts of tort litigation in those countries.
Great. Well, why don't we kind of jump into our first kind of real topic for this particular session. I think one of the great things over the last couple of days that we've learned about this conference, which has been really terrific, is that there's a lot of different perspectives. You know, you've got claimant-friendly, you've got defense-friendly, you've got the funding perspective, you've got kind of the neutral and courts, you've got everywhere in between. I'm sure I'm missing some. But I think a lot of us, or at least all of us, can agree that litigation in Europe and globally, there's lots of differences. You know, there's challenges in handling litigation in different countries, and I know that you all have kind of experienced that firsthand. So Ainslie, perhaps we can kind of start with you, kind of in your role as kind of, if you could touch on this and kind of just the kind of practical realities of handling litigation in different jurisdictions.
Sure. We, as many of you in this room will know, probably because you're coming after us, we're facing claims in a huge number of jurisdictions around Europe at the moment. And the differences in the jurisdictions are really, really significant in terms of the impact that they have on our strategy. It's very important for me to keep in mind the overall picture and the overall approach, because while your claimant lawyers and your funders will be focused on their claims individually, working on the defense side, I've got to keep an eye on all the claims everywhere. And so keeping that in mind, I think, is probably one of the biggest challenges and one of the hardest things about running the claims.
Sure. Felix, any different perspective or any additional thoughts?
Sure. Just touching on Ainslie's points, I think part of managing litigation across different jurisdictions goes back to having a proper legal strategy in place. It's been mentioned on several panels today. And so collating a team that can address issues locally is important. In the Bahamas, for example, we have industry professionals, we have subject matter experts, we have law firms that cater to certain and specific types of litigation. And so doing your due diligence and research for each jurisdiction and location is important. There are platforms like Terralex, which is a global legal networking platform where you can research different law firms in each jurisdiction, know who the subject matter experts are. They will have ideas on successful litigation cases as well for those persons. And so they are the people who you would want to target, who will have the expertise in each location to build a strong legal team once you're thinking of doing something globally.
Yeah, I think that's a really interesting point, Felix. I wonder, I guess for any of you, how, you practice in so many different jurisdictions, there's so many different laws. I mean, like, how do you keep track of that? Like, how are you, you're not probably memorizing the particular law in each jurisdiction, right? Nobody would do that, but kind of how are you operating that kind of as a practical reality? Like, what's kind of the first step in that?
My understanding, it's quite difficult, but you need to trust on your direct counsel locally, on your local teams to advise and to provide you with insights from the local realities. The company, the product may be the same, but in the end of the day, the local law applicable is different. The nuances in a court is completely different as well. The way that the claimants behave, the panel of the plaintiff's bar behave is completely different. So you have to be very open-minded to understand that what is working in one jurisdiction may not work into another, although you're defending the same sort of incident or same sort of litigation. And as Felix mentioned very well, we have built a very strong support network with district counsel, local legal teams in order to sail through these very difficult waters.
I think that makes a lot of sense, Edu. You know, as an outside counsel myself, you know, I often kind of wonder what clients are thinking about kind of how lawyers or law firms will stand out in a particular jurisdiction. And I don't know if any of you guys have kind of thoughts on that as far as kind of if you're thinking about a counsel, you know, kind of is there something that kind of pops into your head that will able you to kind of trust those local experts or local firms? Any thoughts on that, Felix?
I think track record is important. So there's different deciding cases in different jurisdictions. And so once you have an idea of the context of your subject matter, you can do your own research and see who are the experts, what type of cases have they represented in terms of clients, what are the type of clients that they have. And then you can see one track record case of success. So those that are successful, obviously they will stand out. And so there's also some merit in researching and getting referrals as well. So you may have a contact in a particular jurisdiction. Maybe it's a branch or a company that's similar to the type of business you're doing, and you reach out to them and say, well, I have this particular matter. Do you recommend somebody? Is there a referral that you can give on an attorney to represent us in this type of case? So.
Yeah, that's well said. Thank you, Felix. As the outside counsel to me, that's good to know. Well, we've heard a lot today and yesterday about kind of all the different changes that are going on, you know, in the legal system in Europe, and you know all the different types of litigation that are happening as a result. And you know, I wondered, you know, perhaps Ada, if we can start with you. You know, what kind of you're hearing either within the industry or kind of like what you're keeping your eyes open to, you know, about how these things are changing and impacting and kind of, again, affecting the way that you're advising your own business partners and internal clients.
The world is changing quickly. We see that various factors, international factors, are affecting the way global companies do business locally. And well understanding the way that these new laws, behaviors, or new niche of litigations are coming, I think is key to advise the business to be one step ahead when this starts happening. So nowadays there are a lot of discussions, at least on the digital platforms industry, about platform work directive, product liability, AI directive. So be understanding what may change, be prepared to be always compliant and avoid future risks or mitigate future risks that may be created right now, but also partner with other members of the industry, direct counsels, to get better reading of the market in order to be able to be very assertive and provide an accurate assessment for the business.
Thank you, Edu. Ainslie, any additional thoughts besides what Eduardo has said on kind of what you're hearing now? And then I'm going to come back to you guys in a minute, and I want to kind of get your thoughts on, you know, I know none of us can predict the future, but kind of maybe what some thoughts are about kind of how you're advising your own internal clients on kind of, you know, how things could manifest itself in the future and how to kind of get prepared. So I guess let's focus on the here and now, kind of, you know, what are you, I guess, hearing within the industry or things like that that's kind of catching your eye that you're then kind of relaying to your own internal clients?
I think it's paramount as part of my job to stay on top of emerging developments. I look very much to the States to see what areas of, what sectors and what industries are being focused on. So the session this morning was quite useful in that respect. I wasn't aware of the chicken protein claims that are coming. But staying on top of development, staying on top of the changes in the procedure and the substantive law and all the different jurisdictions, distilling that and presenting it in a way for my stakeholders so that they understand the risks that they could be facing is 100% part of my job. Yeah.
Sure. Felix, any thoughts again on kind of the here and now?
Right, similar to what she said, in terms of just emerging areas such as ESG, and I know that's on a topic of today as well. Things like that that are a bit broader in nature. We're still trying to figure out how we will address these, and so it's important to liaise with your stakeholders and senior business executives to carve out a plan that's more proactive as opposed to reactive at this point. And so if you know something is on the horizon, AI for example as well, where the law is still developing, hopefully you can now be having those internal discussions to see what strategies may we employ if there are claims brought against the company. And so you'll be on top of it as opposed to trying to catch up.
Yeah, I think that makes a lot of sense, Felix. Ainslie, I want to come back to you on the kind of the future aspect of it. You know, one thing that I feel like I'm hearing from some of our clients that when they hear about the collective redress directive, when they hear about some of the other directives that are going on right now, you know, some of them are skeptical, frankly, that they're going to get any traction. Some are preparing as if they're going to get some traction just in case, but they're still kind of in a wait-and-see mode. And some are saying, well, it's already here, it's already happening, it's already affecting my business. You know, I guess, what are your thoughts, kind of again, when you're trying to forecast the future, which I know is a faulty business, when you're kind of giving some advice to your, again, internal clients, what's kind of been your approach, or what are your thoughts on that?
I think on the defense side, the reforms and the new procedural rules that are coming in and are being implemented, they're more for the claimants. I think that as a defendant, we have to defend the claims where they are brought against us, essentially. There are differences between the jurisdictions that we need to know, plan for, mitigate as best we can, but we defend the claims that we get. So I see that more as being of relevance and of interest to the claimants in terms of where they bring their claims and how they bring their claims. We have to respond accordingly. We can try and prepare, but it's mainly responsive.
Sure. Edu, any additional thoughts on that?
And I just agree with Ainslie. I think at least in this beginning where the things are changing too fast, it's important to be more aggressive in defending the matters in order to seek to form a good precedent in court or to demotivate the rise of an industry on litigation. We understand that specifically in the European market, it's very different from the US, luckily, but there is nothing preventing this region to start moving towards that direction. So litigating right now here, it's important to have this vision, to be aware that things may change in the future. So it starts as a defendant preparing the grounds to not become an US, for example.
Sure. Felix?
Being prepared is, I think, paramount here, and both of them kind of touched on that already. The only other thing I would add is that when we look at the landscape economically and socially with inflation rates and wars going on, litigation is at an all-time high. And it's only going to increase as people become more financially unstable. Corporations are looking for profits, and so you're going to see a lot of vexatious litigants, frivolous claims. And so manning yourselves internally is important to address these. Sometimes having a hardline approach with defenses is important to flesh out these claims from early onset. And having a strategy that is codified within the business is important.
Thank you. I wondered if we could just touch a bit on any tips that you might give, not to our claimant attorney friends out there, but perhaps maybe to some of the other companies that may be either defending this litigation or kind of evaluating the potential threat of this litigation. I don't want you to, and I don't expect any state secrets to be revealed here, but just kind of any general tips, for other companies and other lawyers for companies that are kind of managing this litigation. Ainslie, any thoughts on that?
Educate your stakeholders. Let them know what's happening, it helps if you've got board members or key stakeholders that have had US experience because they're more understanding and familiar with the litigation climate there, and to the extent that it's they're facing US-style claims over here, that helps, I think, in terms of your governance and your sort of accepting and understanding and preparation for mitigating those risks.
So they're more familiar with the potential risk, in other words, that could kind of be faced here.
Absolutely, yep.
Sure. Felix, any additional thoughts on that?
Stakeholder buy-in is very important, and I'll piggyback off of that to say that that goes into the commercial awareness that I think teams have to have both in-house as well as external counsel. As lawyers, sometimes we look to the solution and what are the steps to get there as opposed to the commercial side of things. And so having the buy-in from stakeholders to know and understand that we are commercially minded, but we're also trying to protect the company at the same time is important. And I think once you've established that rapport with the stakeholders, they will feel comfortable that it's just not a very hard-pressed game that you're playing as a litigator or as a legal counsel, but you're trying to work towards a solution that's pragmatic and practical for all parties.
Yeah, I think that makes a lot of sense, and I think that would resonate with a lot of clients that kind of I interact with. Edu, any kind of parting thoughts on this particular topic?
I think that in addition to keep standard approach on a global basis, and of course tailor-made to each jurisdiction, but understanding that could be a global problem. So you're going to face the same sort of issues in different regions. So to be consistent, advise the business to be consistent on that, the way they approach and respond.
Great. Well, I think now would be a good time, we have some kind of closing thoughts before this, but to open this up for any particular questions that somebody may have, I guess recognizing that, again, I don't think anybody up here is going to be revealing state secrets on how they do things, but any particular questions that you all might have before we kind of get into some closing thoughts?
I had a question. Sorry. I have a question for Eduardo. To your knowledge, I'm not talking necessarily about Uber. My name is Geert Lensens, Brussels, Belgium. To your knowledge, are big companies actually already using artificial intelligence in class actions and in mass actions? That's my question. For example, for data mining, discovery, etc.
I know that technology has been playing a very important role on defending and preparing for discovery. I'm not directly involved on e-discovery or discovery cases because they're mostly on the US litigation. I oversee everything outside the US. But there is already an understanding that it can help, that we can be resourceful if well used.
Yeah. And I would just add from the U.S. side of things, that's something that we, I think, see that, I think, on both sides of the V, that as being explored. Again, whatever it is that can be done efficiently and accurately, that can help reduce the cost and the burden of discovery, which we know can be so high, particularly in the U.S. So it's definitely something I think that's being assessed, and again, on both sides of the aisle.
I would echo that. Keeping the cost down on the defendant side is very important. As you all know, these claims run to the hundreds of millions sometimes. And so finding ways that we can use tech, defendant side, to assist us, because we know that the claimant tech is out there and it's probably more developed than the defendant side tech. But seeing what we can do and how we can use it is really important.
Hi there, yeah, this is really for Ainslie, and it's for Ainslie because you're representing what I suppose we could call a very trusted legacy brand that's about 80 years old or something and globally known. So when you are slapped with a lawsuit, and as you said, there have been quite a few of them lately, aside from looking obviously at the finances and the legal issues, how much does reputation management come into your consideration when you're when you're thinking of fighting or settling, really for your overall strategy, given the reputation of your brand is traditionally very, very strong?
It is very important. Cultural differences and cultural practices, I think, feed into that as well. I work for a Swedish business that has a role in it too. So considering reputation, absolutely. Yeah, don't have anything further.
Yeah, I'll also add that a lot of the clients that I work with, again, more in the product liability space, you know, they have to understand that, you know, they're running a business and that, you know, while whatever value that I put on a case, I may think is a great value, I may think this is a case we should settle or not settle, they also have to look at it from a macro level perspective. That sometimes isn't maybe frustrating for an outside counsel or things like that, where you think that your case is the most important thing that should be on their docket, and most likely it's not, right? They've got a lot of things to be doing, speaking for you all. But, you know, internal stakeholders and other things, and it's not just Patrick Reilly's case that, you know, needs to merit their attention today, so.
Yeah, I think all large corporates who are defending claims of this nature will have communication strategies. They will be key stakeholders in who you're dealing with as well, to be able to manage the risk.
Okay.
One of the roles that general counsel are often assumed to be playing is calming down emotions, and every litigation raises emotions in business owners or anybody else, frankly. So how far from your experience, I don't want to pry in private secrets, but how far can you reflect on that issue that lawyers, particularly internal lawyers or those advising big companies from outside even can help to calm some of those emotions down that can be given rise to?
And let me also, thank you for the question. Let me also add, maybe to the extent you're not able to speak kind of more directly to kind of what your particular general counsel or, you know, something like that, maybe how do you also kind of keep a level head and a balanced when you're dealing with litigation that can be hot, it can be cold, you can have a good result here, you can have a bad result here, and you're kind of keeping things that are kind of, things are coming at you probably from a lot of different directions, so.
Yeah, I would say communication is key, and when you're dealing with senior stakeholders, presenting it in a way that is not alarming is important. So when we get advice from external counsel, a lot of the times it's no offense, but very loaded advice, it's very detailed, it's a lot of legal jargon, so a lot of that goes over the heads of business professionals, and so it's important to consolidate that in a very concise and straightforward way. But you also have to be transparent, and so letting them know and understand, okay, what is the quantum here, what is the exposure here, is this something that is a priority, or this is something that we could kind of deal with on a very conservative level, I think is important. And it's also good to keep them abreast and communicate, like I said, every step of the way, so there's no surprises. And I think once you have that open dialogue and communication, all steps throughout that process, hopefully tempers are down at that point, but obviously if they escalate, you have to kind of act as a crisis manager at that point and try to, you know, calm things down in a way that is respectful but also realistic.
And it is important as well to explain and to properly address the jurisdiction where the lawsuit is, because most of the business managers, they have a US mind or have a US perspective of a litigation can bankrupt a company, and sometimes you're dealing with litigation in a country where it's complex. Indeed, can represent a lot of money in loss, but at the end of the day, it's not catastrophic. So making this clear for the business, for they understand where the problem is or the consequences locally, it's also really important for manage the potential crisis, and just adding to Felix.
Any additional thoughts, Ainslie?
I think that emotions tend to simmer with time, and because these claims take so long to run, there is often an acceptance of the claim that is being faced over the years. So while there may well be a lot of emotion at the outset, I think that that gives way to a more business as usual sort of mindset when facing claims of this nature because they take so long.
So I think if we can kind of touch on some just parting thoughts on this particular topic, I'll kind of leave it open to you as kind of what you want to share. You know, I think one thing that, excuse me, that I think my clients are paying attention to, and I'm certainly paying attention to, and we've heard some mention of it this morning and a little bit yesterday, are some of the underlying laws that are accompanying the Collective Redress Directive that are happening in real time. And I think one of the ones that we heard this morning was the Product Liability Directive. And as a product liability lawyer, that's certainly something that I'm paying attention to. And I heard somebody mention kind of the potential shifting of the burden of proof, right? That's obviously something that my clients are very interested in seeing kind of how it plays out, because obviously that could really affect, you know, how their litigation portfolio and landscape looks, you know, in conjunction with the Collective Redress Directive and the potential increased for class actions. So that's, I think, the thing that's kind of I'm paying attention to most, and my clients are as well. But anything that, I guess, kind of jumps off that, you know, on this particular topic that you'd kind of leave our audience with. Felix, why don't I start with you?
Sure. From an in-house perspective, I think doing your proper investigation from the outset is important when you're advancing these claims. And so that goes back to communicating to stakeholders as well. Once you have a firm position on what the facts are of your case, what the strengths and weaknesses are, you would be able to better strategize what is the next steps. And so when I started on my team, a big part of our fact-finding was sitting down with the business, getting you know, evidence from a very early stage, as opposed to waiting further along the complaint. And so once we would have consolidated all of those things, we had a better understanding of where we need to engage external counsel, if we needed to engage external counsel. And when we did, we had better direction as to what the outcome would be once we liaised with them and got advice from them. And so doing your due diligence in terms of investigation from an early standpoint really would help further along with the litigation process.
Yeah, that makes sense, and it's perfect from what you said earlier, right, which is kind of be prepared. So it's kind of being prepared on all sides of the continuum. So, Ainslie, any thoughts?
I think further to that point, in terms of dealing with external counsel, knowing who you want to use and really building on that relationship is crucial at the outset. Staying on top of who's at the top of the game and what they can offer you is absolutely fundamental.
Edu, any parting thoughts here?
And start monitoring eventually the first cases, see how they are framed, start building the strategy, preparing for what's coming. So I think the thermometer is always seeing one lawsuit popping up here or the one there, trying to see these early signs, I think is really important.
Great. Well, I just want to thank all of our panelists here for your time and for your attention. Oh, sure.
Thank you. So yeah, just a quick one, because we heard a bit from Eduardo about the importance of understanding, you know, what local counsel are saying and what local courts and laws are doing. But we've also heard a lot over the past couple of days about the increasing risk of parallel proceedings and multiple jurisdictions as more and more class actions jurisdictions develop. So, you know, from the in-house counsel perspective, how do you manage the sort of the risk of well, not just the risks, but, you know, how do you manage proceedings in parallel jurisdictions, which are often similar, but maybe developing at different speeds, maybe, you know, different jurisdictions are coming online? Is there a desire to kind of have a, you know, at almost board level or at GC level, a central control of all of the disputes? Do you let them play out for the different offices, the different, you know, international operations, manage them? You know, sort of how do you manage those parallel disputes, or is there a certain level above which it becomes an international concern and below which it just remains a local concern?
Thank you for the question. It's very interesting because lately you have to live locally. So even though it's a global company, what happened in the US may have reflections in the UK. A court decision here may have reflections in the Netherlands. Something happens in Australia today can be used by courts in the African continent. So we have to live locally. So manage those litigations locally, understand the local consequences for the case, but also having an international view, saying whether we lose the case here, whether we have a court decision here, how this can be trigger litigation in different countries. So this helps us to understand and to better manage the portfolio, to see which lawsuits we could settle, which one we want to move forward, going to trial or a final court decision, but always with the mind that we are living locally and we have to deal with them locally.
One thing I'll add is, and I think I mentioned it at the top, so we as outside counsel serve as kind of coordination counsel. In the United States, we serve as coordination counsel for multi-district litigation and state court coordination, and then in Europe and globally, we serve as kind of a global coordination counsel. And so, you know, maybe clients may differ on this view, but I tend to think it's helpful to have a particular firm that serves as your coordinating counsel that can kind of keep on top of things to make sure they know kind of what strings need to be pulled where, to make sure that, you know, one litigation maybe doesn't get out ahead or you're kind of saying the same things throughout. If you have a big enough litigation or legal department, you know, maybe you don't need that, but, you know, that's often kind of one other way in which you can kind of help ensure that kind of consistency and coordination.
Yeah. In response to your question, as you were asking it, the word that popped into my head was carefully. So where you have so many claims in different jurisdictions relating to the same subject matter, developments in one jurisdiction can have big consequences in others. So I think viewing it in the round, from my perspective, is very important to stay on top of the risk as it affects the whole corporation.
Well, if there are no other questions, again, I want to thank our panelists. Appreciate your insights, knowing what you can share and what you can't. Thank you for your time. Hope you all enjoyed it, and I guess we'll move on to the next panel.